Yes, good evening to everybody. Welcome to the class of the All India Bar Examination. It's the 17th cohort, 2022. Yes, again it is disappeared, but doesn't matter because that is today that we are going to deal the professional ethics and then other point is here is class cases of the professional misconduct under the BCI rules. That is the today MCQ. Yes, please now, without wasting the time, I would like to come to the point. I think you could see my screen. Is it? Could you see my screen?
Yes, sir.
Very good, very good. So, All India Bar Examination, Professional Ethics and Case of the Professional Misconduct under the BCI rules, multiple choice questions. Okay, be ready. The first question. Professional ethics can't be contained in a bar council rule, nor in traditional, can't in the books, but in a new canons of the conscience, which will command the members of the calling of the justice to obey rules or morality and utility, I unquote, said by number 1, Neelakanta Ramakrishna Madhavaminam, number 2, Upendra Bakshi, number 3, V.R. Krishna Iyer, number 4, Y.V. Chandrachud. Which is the correct answer? Yes. Participants, even though it is wrong, doesn't matter. There is no minus marks.
Upendra Bakshi.
Krishna Iyer, number 3.
It is a V.R. Krishna Iyer said those things. Professional ethics can't be contained in the Bar Council rule, nor in the traditional, can't in the books, but in new canons of the conscience, which will command the members of the calling of the justice to obey the rules or morality and utility. That is said by the V.R. Krishna Iyer. Number 2, professional misconduct includes the following situations. 1 is false among them. Means 3 are relevant, 1 is irrelevant, odd man out. Number 1, betraying the trust of a client. Number 2, practicing fraud through the certain means. 3, deceiving the court. 4th, receiving the opposing party or their counsel.
I think fourth one is correct one. Receiving the opposing party.
Actually, the feedback it is shown over there. I have to drag it down, but the feedback came on the screen. Yes, the 4th one, it is not receiving, it is a deceiving. It's not the receiving, it is a deceiving the opposing party or their counsel. So that is not relevant to it for the misconducts, including the following situations. Okay, the third question is, the Supreme Court of India dealt professional conduct may involve dash. 1, behavior that is unlawful according to law. 2, immorality. 3, carelessness in discharge of duty. 4, all of them.
I think first one, sir. Behavior that is unlawful according to the law.
No.
If I'm not wrong. No.
All of them, sir.
No.
I think immorality is not.
There is no immorality. Actually, it is immortality. No, it is immorality. I wrote immortality. So the answer to the third question is 2. It should be immorality, but I wrote immortality.
Immortality, yes.
That is not corrected with that one. The right place is immorality, the right. If immorality is there, number 2, then all of them is correct. Is it clear?
Yes.
Say yes.
Yes, sir.
Good.
Yes, sir.
So now the fourth question.
Very careful with spellings also.
Yeah. That is only the sharpness of the words, because that people would like to confuse you, because in your running speed of language reading, you read as a immorality. You never read as immortality. unless until you pay the attention to it. The fourth question. In decided cases law of dash, professional misconduct may involve the preceding question options. So in which case law it is decided? State of Punjab versus Ramalinga Reddy, State of Punjab versus Ram Singh, State of Punjab versus Ram Kumar Singh, State of Punjab versus Kaur. Question is, in the decided cases, and which case law deals about the professional misconduct may involve preceding questions options also. So the four options I have already.
I think second one, sir. State of Punjab versus Ram Singh.
State of Punjab versus Ram Singh is the right answer. Yes, that is the right answer. So next, fifth question is, dash of Advocates Act of 1961 deals with the conduct of the advocate. Conduct or conduct. CONDUCT. Number 1, chapter 4. Number 2, chapter 5. Number 3, chapter 6. Number 4. Yes, number 4, chapter 7.
Chapter 5, sir. Chapter 5.
Yes, it is a chapter 5 is the right answer. So next question is, yeah, this is the right answer. Chapter 5 is the right answer. So next question is, sixth question. According to section 31, subsection 1 of the Act, means Advocate Act, when the State Bar Council has, number 1, a basis to believe that an advocate engaged in any act. Number 2, that makes him guilty of any sort of conduct. Number 3, they shall forward the matter to the disciplinary committee for the disposal. Number 4, all of the above. That means one is not connected with one. One is a false among them. Better I have to write one is false among them. Yes.
I think one, sir. Base believe that advocate engaged in any act is nothing is there. I think one is correct.
Let me check it. False. Yeah, that makes him guilty of any sort of conduct. Yes, that is the answer. Where is the one has disappeared? I don't know. Because 2, 3 were there, but one is somewhere gone. Where it is gone? Yeah, it is gone like this because it came over there. Yeah. No, a basis to believe that an advocate engaged in any act. No, that is not the answer. So, number 2, that makes him guilty of any sort of conduct. Number 3, they shall forward the matter of the disciplinary committee for the disposal. Number 4, all of the above. The answer is
Number 2, sir.
number 2. Actually, that makes him guilty of any sort of misconduct. Here, misconduct, I removed the miss and I put the conduct. Sort of conduct, no, sort of misconduct. So that is not a relevant false statement, that is. So better I have to write false statement. Yes, that is, now it is correct. So that is the way that we can make it out. I removed the MIS and I put it conduct only, but is the misconduct is the right answer for that one. 7th question. Non-performance of duty dash, which one is correct? Which one is correct? Number 1, the atmosphere also known as a dereliction of one's duty. Number 2, this context is also known as a dereliction of the one's duty. Number 3, this environment is also known as a dereliction of the one's duty. Number 4, this situation also known as the dereliction of one's duty. Which one is the correct among the 4? The meaning of the non-performance of the duty. The explanation of the non-performance of the duty. You look at closely because I changed the wordings and the appropriate word should be there. And that is the right answer. Make a close follow-up and you know it, and you can use the logic, you can directly reach to the answer. That's why I am training from the various angles. Anyone?
Option 2, sir.
No. Number 4, the situation. This situation is also known as the dereliction of one's duty. Not environment, not context. But contexts are very close it, because generally we'll use it. But here it is not the context, it is the situation. Atmosphere also we don't say. Atmosphere will not make it out here. So the 7th question, right answer is 4th one. Is it clear? If you say yes, then I proceed.
Yes, sir.
8th question. Can anyone unmute and read? 8th question. Oh, it's a lengthy question. I will read it. It was clarified by the Apex Court in the case of Dash that is an obligation on the lawyers entrusted with a case and its brief to follow the principle of the professional ethics and consequently protect the client's interest. The failure to do so would be a professional misconduct. In which case law it is dealt like that? Number 1, C.V. Rangadurai versus D. Gopalan. Number 2, V.C. Rangadurai versus C. Gopalan. Number 3, V.C. Rangadurai versus D. Gopalan. And 4th, V.C. Rangadurai versus D. Gopal. The right answer is V.C. Rangadurai versus D. Gopalan, 3rd option. Number 3 option. The 3rd option which I am highlighting here, this is the right answer for the question that is decided in the case law and which is a misconduct. Is it clear? Say yes.
Yes, sir.
Good. So 9th question, yes, you can read. Anyone can unmute and read. Read. Anyone can unmute and read. 9th question.
9th question. The Supreme Court noted that it would lead to misconduct in case a lawyer fails to furnish the necessary documents required to proceed with the case despite of recurrent adjournments was observed in the case of Dash. Number 1, Mohammed Jabir versus
Tanai.
Balaratna. Sir,
Tanai.
Ratnayu.
Ratnai.
Second,
Yes.
okay, sir. Muhammad Ilyas versus Balaratnai. Option 3, Muhammad Ismail versus Balaratnai. Option 4, Muhammad Usman versus Balaratnai.
Number 3.
Number 3 is the right answer. Muhammad Ismail versus Bala Ratnai is the right answer, where the Supreme Court noted that it would lead to the misconduct in case a lawyer fails to furnish the necessary document required to proceed with the case despite the recurrent adjournment was observed in the case of. Because it's the negligence on the part of the advocate not to file the relevant document in spite of the repeated adjournment also. So 10th question. The term professional misconduct has been clearly defined in the Black's Dictionary as a transgression of some established and definite rule of action, a forbidden act, a dereliction of duty, unlawful behavior, improper or wrong behavior. Its synonyms are dash. 1 is false. Number 1, misdemeanor. Number 2, impropriety. Number 3, mismanagement. Number 4, negligence or carelessness.
The one's the first one?
Misdemeanor.
Yes.
No.
One.
Not 1 or 2, so that's only.
Number 1.
Answer is 4. Negligence or carelessness is that, because its synonyms are misdemeanor, impropriety, mismanagement, offense, but not negligence or carelessness. But I put over there negligence or carelessness. I removed the not, and that is a false. Is it clear?
Okay, sir.
Okay, 11th question. The disciplinary committee of the State Bar Council, after hearing both the parties, may, among four, one is false. Find out the false one. Number one, dismiss the complaint or where the proceedings were initiated at the instance of the State Bar Council directs the proceedings be failed. Number two, reprimand the advocate. Number three, suspend the advocate from the practice for such a period as deems fit. Four, remove the name of an advocate from the state roll of advocates.
I think 2-1, sir. 1, 3, 4 is there actually. Reprimand and the advocates.
No.
Huh?
The first one.
Sir, definitely they can remove it. Suspend also is the option is there.
No.
They can suspend it according to
But
35
I
clause
say
1.
one is false. I said one is false. The rest three are correct. It is a feedback if you see it now. Despite
One, I think.
dismiss the complaint where the proceedings are initiated at the instance of the State Bar Council that proceeds be filed. But I wrote here failed. Did you observe? I wrote here be failed, but the actual the word is filed. See, that is the sharpness. It is not failed. F-A-I-L-D, failed. It is a case is filed. F-I-L-E-D. Is it clear? The other three is
Yes, sir.
2 is right, 3 is right, and 4 is right. But only the one I made it here is I wrote failed, but it's not failed. It is a filed. F-I-L-E-D. So next question. Anyone can unmute and read? 12th question. Anyone can unmute and read 12th question. Anyone can
In the
unmute
case,
and read.
yes, sir. In the case like dash, the court delivered the decision in such a way that it created a notion in the minds of the wrongdoers that offenders will be punished accordingly. Option 1, S.J. Jadhav versus Mustaq Haji Mohammad Yusuf. Option 2, S.J. Jadhav versus Mustaq Haji Mohammad Yusuf. Option 3, S.J. Jadhav versus Mustaq Haji Mohammad Yusufian. Option 4, S.J. Jadhav versus Mustaq Haji Mohammad Yusuf.
The case law is the fourth one. J.S. Jadhav versus Mustafa Haji Muhammad Yusuf. There it is decided, the court, what? The decision in such a way that it created a notion in the minds of the wrongdoers that offenders will be punished accordingly. So that is the idea behind it. So that is the whole idea behind it. 13th question. Contempt of court may be defined as, number 1, an offense of being obedient or respectful towards the court. Number 2, its officer in the form of certain behaviors. Number 3, defies the authority, justice, and dignity of the court. The 4th, all of the above.
All of the above, sir.
It is all of the above. No. There I committed.
No, sir.
a mistake.
No.
I committed a mistake. No, not all of the above.
It's the first one, sir. First one.
I intentionally removed
No.
something.
First one is wrong.
Yes, an offense of being disobedient, not obedient. Here, I intentionally made.
Number 3, sir.
Yeah, it should
Number
be
3.
disobedient, but I made obedient. So that is not. So not all of the above is right. It is number 1 is the right. There should be disobedience
No.
or disrespect.
Sir,
Yes.
sir
Please.
number 3, sir.
I told you the number 1.
Sir, you are not asking you are asking contempt of court may be defined as
Mm.
so
But
one is not contempt.
actually,
If you are obedient to court,
I should have to make it that one is false. Yes, among them one is false. Other are very much correct. At that instance, I am right because number one, offense of being disobedient or disrespectful towards the court. That will be the. I removed the dis both the places. Did you and respectful also I removed the dis and obedient also I removed the dis. So answer is number one. Now 14th question. In various cases involving the contempt of court, the court held that if any advocate or legal practitioner is found guilty of the act of contempt of court, he, she, may be imprisoned for dash years and may be suspended from practicing as an advocate. How many years? Number one, 4, number 2, 5, number 3, 6, and the fourth option is 7. How many years imprisoned for the contempt of the court?
I think 4, sir. I think cannot be 7.
Never.
maybe
Six.
6
There
months.
cannot be 7.
6 months.
Maybe 2, sir.
Oh.
5 years.
6.
Number 3.
Number 3 is the right answer. 6 years.
6 months, sir. Not years, I think, sir.
Yes.
It is not years, I think, sir. It may be months. 6 months.
Is it?
Yes, sir. Please check up. Just contempt is only
It's a 6
respecting,
months.
Might
like
be.
that.
Okay, I do admit it. Either, but anyway, note down the point. Either 6 months or 6. Okay. Next, 15th question. In which case law an advocate is suspended from practicing as an advocate because of the contempt of court? Inre Vinayak Chandra Mishra. Number 2, Inre Vinayak Chandra Mishra. Number 3, Inre Ajay Chandra Mishra. Number 4, Inre Uday Chandra Mishra.
Number 2.
Number 2 is the right answer. Inre Vinay Chandra Mishra. In that case, an advocate, because of the contempt of court, he will be suspended from the practice. So next, 16th question. The court also held that license of the advocate so practice a legal profession might be cancelled by the dash in the exercise of the contempt jurisdiction. Number 1, Supreme Court. Number 2, High Court. Number 3, District Court. Number 4, 1 and 2, true.
4, 1, sir. True, 1 and 2.
1 and 2, that is the fourth option is right. Means both the Supreme Court and the High Court. Anyone, either the Supreme Court or the High Court can deal such a matter. Next question. 17th question. Dash of the Advocates Act empowers the Bar Council of India to frame the rules and standards for the professional misconduct. Which section says? Number 1, section 47. Number 2, section 48. Number 3, section 49. Number 4, section 50. Answer is, shoot it, even though it is wrong, doesn't matter. At least your logic will play.
Section 49, sir.
Yes, it is section 49. Option 3 is the right answer. Next question. 18th question. Under the Advocate Act, no person has a right to make advertisement or solicit. It is against an advocate's code of dash. Number 1, conduct. Number 3, procedure. Number 4, ethics. Number 3, ethics. Number 4, culture.
Number 1.
No.
No, not number 1. It's a procedure, sir.
Intentionally, I kept this conduct because
It's a
generally we'll say code of conduct.
code of misconduct.
I thought, no, I want to confuse because everybody knows the code of conduct is not good. So I put the number 1 as a conduct, number 2 as a procedure, number 3 as a ethics, number 4 as a culture.
I think second one, sir.
No, ethical value.
Ethical value.
Ethical
Ethics, sir.
values are there. You are not supposed to make. So it's a code of ethics. That means right answer is number 3 for 18th question.
Sir, no, code of conduct only hoga, sir. Code of ethics means it is there, sir. Any such ethics order?
Ethical values lo vastadi adi. Code of conduct
Okay, sir.
general conditions lo vastadi adi.
Okay, sir.
19th question. In which among 4 is not relevant to the professional misconduct are as follows. 1 is not amount to misconduct, professional misconduct. Number 1, dereliction of duty. Number 2, professional negligence. Number 3, misappropriation. Number 4, changing slides.
First one.
Changing slides.
Number 1.
Number
No.
1.
Number 4 is
Changing slides is misconduct
not
only.
slides. That is changing sides. I added L.
Number
Okay,
four.
okay.
It is changing
Okay.
sides, that is not slides.
Yes, sir.
Added intentionally
4, sir. 4.
L. So answer is 4, which doesn't come under the professional misconduct. Now next, 20th question. Which among 4 is not relevant to professional misconduct are as follows. I say not. Number 1, contempt of a court and proper behavior before a magistrate. Number 2, furnishing false information. Number 3, giving improper advice. Number 4, misleading a client in court.
Sir, I think first one, sir. The misconduct, it comes professional misconduct for the purpose of the clients. I think the 1 is the correct one.
Number 3.
What exactly the word I changed? You tell me.
No, sir. You said magistrate. Cannot be contempt of court and proper behavior before magistrate. It is not the professional misconduct.
Improper behavior, I think.
Yes,
The right
improper
word.
behavior. First one.
I removed the im and I put the proper behavior to see that whether you could notice it or not. Furnishing false information, clearly it says, yes, it's
Yes,
a professional misconduct. Giving improper advice clearly says it's a professional misconduct.
misconduct.
Misleading the clients in court clearly says it is the professional misconduct.
Professional.
When you see the contempt of court and proper behavior, there is something fishy. Either it should be improper behavior or improper or yes, that is only the word, because behavior is misbehavior, we can say also, because we don't say proper misbehavior. No, either you say improper or you say misbehavior, but we never say proper misbehavior. Is it clear?
Yes.
Okay. Now next question, 21st question. Which statement is false among 4? Number 1, not speaking truth. Number 2, disowning allegiance to the court. Number 3, moving application with informing the similar application has been rejected by another authority. Number 4, all of the above.
The above.
Feedback.
Fourth one, sir.
Moving application without informing. I removed out. OUT out. Without informing the similar application has been rejected by another authority. And hence, answer is number 3. I know that most of the people think that all of the above, they will tick it because they, of course, is the overlook because of the time factor. So, without actually the thing, but I removed the out, OUT out, I put the third with informing that. No, not with informing. So the answer is number 3 for the right answer. Yes, anyone can unmute and read 22nd question.
Which is a false statement? Suggesting to bribe the court officials, option 1. Option 2, forcing the prosecution witness to say the truth. Option 3, moving application without informing that a similar application has been rejected by another authority. Option 4, all the above.
Number 1. Number 2.
Number 2 is the right answer. What should be the right what I did it there? Can you tell me? I did what the thing I did? Where you can say number 2 is a wrong statement. Forcing the prosecution witness not to say the truth. I removed the not.
Yes, sir.
I removed the not. You have to give the reason also. See, forcing the prosecution witness to say the truth, and here the forcing the prosecution witness not to say the truth. So when you not to say the truth is there, it is a correct one. But when I say said the truth, it will not come under the professional misconduct. So 23rd question. BCI performs the regulatory functions by number 1, prescribing the standards of the professional conduct, and number 2, etiquette, number 3, by exercising the territorial jurisdiction over the bar, number 4, all of the above.
Option 4, sir. All of the above.
I think
One
it's
is
3,
not
sir.
related actually. One is not
Three.
related.
3 ones, sir. Exercising
One
territorial
is-
jurisdiction over the bar.
Okay, one is not related.
One is not related means option 3.
Option
Yes. One is not related means by exercising not territorial, it is a disciplinary jurisdiction. But I wrote territorial jurisdiction.
That one comes in
What
CPC.
is by exercising the disciplinary jurisdiction over the bar. So that would be the very relevant to it. But I changed the disciplinary to the territorial, so that is not related to the right statement. Okay. 24th question. The Advocates Act 1961 is the act number. Which number of 1961? 23, 24, 25 or 26?
25, sir.
25 is the right answer. The Advocates Act 1961, Act number 25 of this 1961. Now, 25th question. The Advocates Act 1961 is revised version of which one? Number 1, Indian Bar Council Act 1923. Number 2, Indian Bar Council Act of 1924. Number 3, Indian Bar Council Act of 1925. Number 4, Indian Bar Council Act of 1926. 4
1925, sir. Indian Bar Council Act 1925.
26, sir.
1926 is the right answer. It is the revised version of the Indian Bar Council Act of 1926. That means for 25th question and the 4th is the right answer. There.
Okay.
Next question. 26th question. Special provisions in relation to the Union Territory of Goa, Daman and Diu is given under the section dash Advocates Act of 1961. Is it number 1, 58 AB, number 2, 58 AC, number 3, 58 AD, number 4, 58 AE?
AE, sir.
Capital E,
AE.
capital E. That is the right answer.
Yeah.
Number 4th, a special provision for relating the United Territory of the Goa, Daman and Diu is given under the section 58 capital E and capital E of the Advocates Act of 1961. So that is the right answer for that one. So now another point. The short title of the Advocates Act 1961. What is the long title? Supplementary question. The short title is Advocate Act 1961. What is the long title? Here I have given. An act to amend and consolidate the law relating to the legal practitioners and to provide for the constitution of Bar Council and an all India bar. So that is the long title of the. Okay, next question. Long title and short title, whether they are internal aids or external aids. Supplementary question. I repeat the question. The long title or the short title, whether they are internal aids or external aids. or we can also say intrinsic aids and extrinsic aids. It comes on the interpretation of statutes. If you don't know, you say pass on. Yes? Are you hearing me? Are you hearing me?
We can hear you, sir.
But why you are not giving it? At least say pass on. If you don't know, say pass on. I will give the answer.
Yes, sir. Pass on, sir.
See, which is internally taken, that is the internal aids. And the internally taken from the statute means bare act, from the sections. So it's called intrinsic aids or internal aids. When you take from the outside of the source, we say the external aids. So that was the comes here I made the Advocates Act 1961, Act number 25 of the 1961, where the short title, this act may be called the Advocate Act 1961, but you can see here the long title. See, this is the long title of the act. And how many chapters are there in Advocates Act? Supplementary question. How many chapters there in Advocates Act?
7, sir. 7 chapters, sir. 7.
Okay. How many sections are there in Advocate Act?
Sections will be around, not sure, sir, around 50, I think 60, sir. If it's not wrong, so 60. I think so. I think 62 something. I think 60.
See here, 60 is there, power of the central government to make rules. So, chapters are 7. How many schedules are there?
I think more schedules.
They say schedule, but I did not see the schedule. Let me scroll down.
No schedules at all.
When I see the schedule, because they wrote schedule there, because I also checked. They wrote the schedule. When I scroll down, I could not see. Only the 60 is the only the section that we will find it here. There is the power of central government to make rules. And so a supplementary question they may ask you from making, what is the definition of a judge or so and so. And it is in this act, definition clause is given in the section 2. But in some of the acts, that is called interpretation clause is there. That is nothing but definition will be given in the section 3 in some of the acts. But generally, a practice will be there. Definitions will be given in only in section 2. See, here I shared the screen where the definitions are given under section 2. Is it or not? Say yes.
Yes, sir.
Yes. So supplementary questions in this way also they can ask it, and prepared this much today's class. And the next class we will see company law. When you see the company law, don't go the old company law. See the new company law. Am I right?
2013.
Yes.
Yes.
Because don't go, because that is not applicable over there to my knowledge. The current one is because it is a 2022. This is, if any new law has come, let it be for the, because in India it is a 3 years course for the LLB after graduation, but a 5 years course after the intermediate. But in Tanzania, in certain universities like University of Dar es Salaam, it is 4 years course, and 1 year it is the law school of Tanzania. One should have to go and pass it. And here they will grill it more. 6 months they will make the theoretical classes. 6 months you should be attached to a court, and you will be there to learn the things. So there would be a ceiling would be there for the passing here. The Chief Justice make the ceiling. This year, generally it is a practice. They cannot make it as much as they can. because they don't want to dilute the legal profession. And the high-earned people are lawyers here. I repeat, high-end people are lawyers here.
But most of the countries, high-end people are lawyers only.
Yes,
Go to any other country.
yes,
But Tanzania, sir, I think some people are studying in Andhra, coming from there and studying in Andhra.
yes. Because not only Andhra and the Nagarjuna, Pune.
No, Yale University, lot of, I think around 15 students, 20 students are studying from Tanzania.
Yeah. The reason is they will be sponsored people. Those are studying, and if they study in the UK and USA, they have to pay from their wallet. And if you study in the India, they save at least a good amount of money because the
Yes.
cost of living is very cheap. Number one. Number two, fees are very less. Number two. Number three, books are cheap rate that you will get it when you compare with the other cost. So that was the reason most people, those who are sponsored to save the money, they say, no, better will you go to the so-and-so place and we can study over there. Because if you study in other country or study in the common law country like India, they feel more happy if they enrich you a lot in India by studying over there, because Indian teachers, they do have the feeling, and it's the true also, they are dedicated in teaching. So here in Tanzania also, the people will praise the Indian teachers because they don't have any other vices and they don't indulge in any activity, and moreover they are fear of God people are there, and they most of the time they will spend in the reading and research and taking the classes. Hence they are very much honest in teaching, and they will teach in such a way we could understand in a better manner. So that notion still the Tanzanians, everybody is having here. Okay, with this tomorrow class that we will see the company law, the new things that you can make it out. And you know that I'm teaching now in the Moshi, that is the MOCO, that is the Moshi Cooperative College, University, and where I'm taking the classes here as an expert. The reason is people know my capability and my caliber, and here the most of my students are lecturers here and where they are working now. So thank you very much. And with this, I would like to stop it. And bye. Have a good day. Jai Hind.
Tanzania.